next case is a very important case. To my mind, it sets a very important precedent. Besides the facts of the case, there's an important point that comes from this Respublica case that we'll discuss now. But just in background, the applicant, in this case Respublica, sought a declaratory order from the High Court, Gauteng Division, Pretoria, confirming that the letting of accommodation to TUT was a taxable supply of commercial accommodation subject to VAT, and that VAT should only be paid on 60%. So we know there's special rules for the letting of commercial accommodation, and the value of supply rule says you're only going to be levying VAT on 60% of the value of the all-inclusive charge. But what happened here is that the taxpayer, Respublica, approached the High Court for a declaratory order. SARS opposed the application on the basis that, and you would expect SARS to oppose it, but SARS opposed the application on the basis that, amongst others, the court did not have jurisdiction to hear the matter. So SARS says that you can't go to the court for a declaratory order, the High Court. Can't do that, that's what they raised. But in this regard, the court confirmed that it was possessed of the necessary jurisdiction to hear the matter, and it said specifically, the Tax Administration Act does not ask this court's jurisdiction to hear the application, as this matter involves a question of law and also because there is no disputed assessment in respect of which it could raise an objection. So the judgment confirms, and this is important in case law, the judgment confirms that a taxpayer may approach the High Court for a declaratory order where the application involves a question of law and there is no disputed assessment in respect of which the taxpayer could raise an objection. So the matter was then further argued on the interpretation of the VAT Act. Now, the court, having dealt with whether or not they can give declaratory orders, and the court confirmed that they can in the circumstances, now let's go to the facts of the case. Respublica entered into a 5-year agreement, Respublica being the taxpayer. Respublica entered into a 5-year agreement of lease of immovable property with TUT. TUT in turn let the property to its students during term and to other people during holidays when the students left and went to home. TUT would pay a monthly amount in respect of the rental to Respublica, inclusive of an amount in respect of utilities. Now the arguments. SARS's arguments. So obviously SARS wants Respublica to account for VAT on 100% of the invoice value, whereas the taxpayer Respublica wants to account for VAT at 60% of the value, and that's really the issue. So let's see what SARS's arguments were to get to their case, to have the taxpayer account for VAT on 100%. SARS contended that commercial accommodation, as defined, was not provided for the following reasons. It says that commercial accommodation, for the purposes of the VAT Act, should be interpreted with reference to the dictionary meaning of lodging, and therefore pertains only to natural persons. So what SARS is trying to say is that only if you have a hotel, for example, that provides lodging to natural persons who come and stay. Not a case where you have a lease and then a sublease to the actual natural person. It says that the main agreement should be between lessor and natural person, if you will. And in this case, there was clearly the 3 steps. Okay. SARS further argued that there is no nexus between Respublica and the students. To say, well, even if you look at the 3 phases, lessor, sublessee, student, there is no nexus between the Respublica, the lessor, and the students. TUT, SARS further argued, should be regarded as a tenant and not as a lodger. Now the arguments continued for the taxpayer. The students are an integral part of the agreement. This is now arguments for the taxpayer. The students return home during the holidays, rendering their stays temporary, because it has to be temporary to qualify for commercial accommodation. The VAT Act itself does not specify that a lodger must be a natural person. The VAT Act does not say that. And SARS, so the argument for the taxpayer went, sought to interpret the phrase commercial accommodation too restrictively, and that the phrase did not relate to the meaning of lodging. Further, the taxpayer argued that Respublica provided domestic goods and services to the students. Now let's look at the judgment. Having looked at the arguments for SARS and the arguments for the taxpayer, let's look at the judgment. And with respect to judgment, seems a bit odd, but we'll deal with it. The decision revolved around the interpretation of the VAT Act the court interpreted the relevant provisions in the context. This is important. The court interpreted the provisions of the VAT Act in the context of the agreement between Respublica and TUT, and it held that SARS's reliance on the sterile dictionary meaning of the word lodger and lodging is faulty, as it does not take into account the underlying purpose of the lease. So I'm not sure whether this is a shift from the courts into the purpose of interpretation of legislation, but nevertheless, this is what the court held. The court further says a nexus between the lessor and the end user, the students, is not a requirement to meet the definition of commercial accommodation. SARS is plucking arguments from the air. It says, but you look at the VAT Act, it says the nexus between the lessor and the end user is not a requirement to meet the definition of commercial accommodation. The court went further. It says that the 5-year agreement, because it was a 5-year agreement between Respublica and TUT, the 5-year agreement does not negate the temporary requirement, as this interpretation also loses sight, again, of the purpose of the lease. Students return home during holidays and do not occupy the property continuously. The agreement itself states that utilities form part of an all-inclusive charge. So to get to the 60%, you must make an all-inclusive charge. And the court was not willing to ignore the agreement. It said that it forms part of an all-inclusive charge. And it says that the supply of domestic goods and services as meant by the VAT Act was common cause. So SARS did not dispute the fact that domestic goods and services were supplied as is required by the definition of commercial accommodation. And it says further that SARS's method of interpretation would result in absurdity. And then the court goes on to say the legislator would not have imagined that all tertiary institutions would own properties to accommodate own students. Outsourcing would have been foreseeable. And then it goes on to say commercial accommodation should be read together with the purpose of the lease in order to arrive at the most sensible meaning. The literal interpretation followed by SARS was not conducive to business, and in addition overlooked the landlord's maintenance expenses in respect of the student accommodation, and the decision therefore went in favour of Respublica. So what we take from this case is that the accommodation is a taxable supply of commercial accommodation for VAT purposes, and that you can use the 60% value of supply rule in section 1010 of the VAT Act. Very, very important case. Even if you don't deal with commercial accommodation and lessors and sublessees and final tenants, whatever you want to call it, take at least one thing from this judgment, and that's the fact that the court can be approached for a declaratory order, in essence doing what you do with the VAT ruling process. And it might even be cheaper, and with respect, you might in some cases, but not all, get a better ruling or judgment than you might if you had gone the advanced tax ruling route.